The question, Mr. Chairman.
Senator, would you restate the question, please?
Yes. Could someone describe the limited circumstances? I don't know what they are.
Well, this amendment would simply say if one of the parties who has a cause of action under this legislation, if it passes, proceeds in bad faith, then the judge has the right to order the bad faith litigant to pay the other side's attorney's fees. And what is bad faith is generally determined by the judge on an ad hoc basis, case-by-case basis.
Senator Kennedy, I'd like to make a comment. This has also in some forms been characterized as loser pays.
Right.
And I have uniformly opposed that concept every step of the way in my service in the Senate. But I do believe that this is extraordinary because we are dealing with resources on both sides of the equation. It isn't the victim in a contingency lawsuit who has no resources and is risking everything if he loses and it's found out that he filed the lawsuit initially in bad faith, but rather two entities, one being big tech and the other being the providers who have some wherewithal and resources to compensate the prevailing party in that circumstance. So I'm going to make an exception and support this amendment, although it does run counter to where I've stood in the past.
Mr. Chairman.
Senator Cruz.
Thank you, Mr. Chairman. I appreciate the amendment offered by my friend Senator Kennedy. I'm going to oppose this amendment. In the instance of lawyers' fees and losers' pay, they fairly systematically benefit the big guy and hurt the little guy. In this instance, we've identified the big guys and little guys. The big guys are the big tech behemoths, and the little guys are the local journalists that everyone here is giving speeches about how we want to help. I think telling local journalists, if you have any lawsuit under the bill, you can be stuck for the millions of dollars of lawyers' fees for Google. It's a good way to bankrupt a bunch of local newspapers or ensure they never bring litigation under the suit. And as I read it, at least looking at the amendment, I don't see anything about bad faith litigation. I see it just simply Section 7 is a cause of action for litigating on this. And so we can have a broader discussion about loser pay across all of litigation, and there are pros and cons to that. But the idea that we would give a special subsidy, a special boon to big tech, that big tech and only big tech gets loser pay. So if anyone tries to sue these giants, they're stuck for the lawyer fees. I think that is ill-advised.
I would agree with my good friend Senator Cruz if he were right, but he is not. It's a very rare circumstance, I know, but this door swings both ways, and I think the amendment's pretty clear that a litigant, whether it's social media or a broadcaster or a newspaper publisher, has to proceed in good faith. And that standard applies to both sides. And I think the senator, my friend Senator Cruz, is a very able litigator, and I think he understands that it's a level playing field. If you want to file a frivolous lawsuit, that's okay, but under this legislation, you're going to have to pay the other side's attorney's fees. And it doesn't just favor big tech. I would never do that. It favors the smaller entity as well.
Could I ask Senator Kennedy a brief question on that clarification?
Senator Cruz.
Senator Kennedy referenced good faith. My understanding of the bill is that good faith is the obligation for how the parties negotiate under the bill.
Right.
And if either party doesn't, then you can have a private right of action and bring a lawsuit. But the attorney's fees here are not predicated on a good faith lawsuit. In other words, this is not like a Rule 11 sanction for a frivolous lawsuit. This is, if either party alleges the other party didn't engage in good faith negotiation, you can sue, and it may not be a frivolous lawsuit, but let's say it was 51-49 and you're on the 49 and you lose, boom, you get stuck with all the attorney's fees. So it's not bad faith litigation. Am I understanding it correctly?
Well, I'd make 2 points. As usual, you make a good point, Senator. Number one, that's why God made judges, is to decide what's frivolous, what's in good faith, what's not. And as you and I both know, that is determined on a case-by-case basis. Number two, it's often said that stupidity is like pornography. It's hard to define, but you know it when you see it. In this case, I would substitute stupidity for good faith. And it's impossible to define good faith, as you know. That's why we have a judge to determine that. And they do it all the time, particularly with respect to Rule 11 sanctions.
Senator Blumenthal?
Just a brief comment, Mr. Chairman. God may have made judges, but we're making laws here. And I just want to point out, as to the laws involved here, that the manager's amendment very carefully defines the scope of the right of action. And with that in mind, the bringing of a baseless or frivolous lawsuit is, in effect, also defined by the right of action. So I think that the amendment here clarifies a point that is currently accepted under the law, as Senator Cruz has pointed out. Rule 11, other state sanctions provide for penalties to discourage or punish the filing of baseless cases. That's the law already. I have opposed consistently, and I'll continue to oppose, unnecessary limitations on access to justice, which are the result of the loser pays provisions that have been offered in the past. I think that an exception is warranted here. I'm going to support this amendment. The would-be plaintiffs in these cases are comfortable with the amendment, and so I will support the amendment as an exception to my general opposition to loser pays fees, as the chairman himself has articulated.
You're a fine American, Senator.
Anyone else seek recognition?
Just to associate
Whitehouse.
myself with your chairman and Senator Blumenthal's remarks on this.
Anyone else seeking recognition? Senator Lee.
I'm a little torn on this one. Senator Cruz makes an excellent point. In this circumstance, though, given that the standards of the bill, the way in which the arbitration decisions are to be made, all of the cards are cut in favor of the publisher, and so in this circumstance, it might make sense to do that, and I'm inclined to support it, the amendment.
If no one else seeks recognition, the question is on the adoption of the amendment. Can we do this by voice vote, or do we wish a recorded vote? All those in favor of the Kennedy Amendment 22A64, say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it. The ayes do have it.
Mr. Chairman, I ask that it be recorded as a no on that vote.
Amendment is adopted with notation that Senator Cruz voted no.
My second amendment, Mr. Chairman, is SIL A65. The bill right now has a sunset provision requiring that the bill would become effective after 8 years. This would reduce that to 6 years.
Anyone wish to speak on this amendment?
I'm supportive of this amendment. Again, something we worked out. Appreciate willingness to work it out.
If there is no additional request to speak, the question is on the adoption of the amendment 22A65. All those in favor say aye. Aye. Those opposed, no. The opinion of the chair, the ayes have it. The amendment is adopted.